Margot Delacroix, step away from the paper. This is about the transcripts.
On what grounds exactly? What is it you think you can actually prove here? A draft is not a final record. You cannot pin a cert of transcript.
Marguerite Delacroix operated without oversight for 28 years as the official court reporter for Ashford County Superior Court. Hundreds of defendants, attorneys, and appellate judges depended on her transcripts as the unalterable record of what was said under oath. Not one person checked.
4 cases, same edit, same defense intermediary. That's what we're pinning it on.
She would not get the chance to explain it away. Within 48 hours, the Ashford County Superior Court would suspend her certification, seize 23 years of stenographic backups from her home office in Westbrook, and begin pulling courtroom audio for every felony trial she had touched since 2019. $84,000 in bribes, 4 criminal cases altered, dozens of substantive divergences between what witnesses actually said under oath and what Margot Delacroix typed afterward. By the end of the audit, the integrity of every verdict she had ever certified would be in question. Quick question before we continue. Have you ever assumed an official document was accurate just because someone with a title and a seal signed it? Drop your honest answer in the comments. And if you're not subscribed yet, now's the time. We cover the cases mainstream coverage walks right past every single week. Marguerite Yvette Delacroix was born in 1967 in Baton Rouge, Louisiana, to a father who worked as a court bailiff and a mother who taught business and secretarial skills at the parish vocational school. The family moved north when she was 9 years old, settling into a tired 2-story rental on the outskirts of Westbrook, so her father could take a sergeant-at-arms position with the Ashford County court system. By the time Margot was 11, she could already type 65 words per minute on her mother's 1958 Royal Quiet Deluxe, a heavy black machine her mother kept on the kitchen table between dinner and the morning paper. Her mother taught her the rhythm of stenography the way other mothers taught piano: repetition, posture, the clean strike of the key. Margot's middle school report cards described her as exceptionally focused, quiet to the point of being easy to overlook, and the most accurate transcriber in the 8th grade. She entered Westbrook Central High in 1981 and joined the school newspaper as a typist rather than a reporter. She preferred to set the words of others rather than write her own. She graduated in 1985 and enrolled at the North State Court Reporting Institute, a small, accredited program housed in a converted office building 3 blocks from the county courthouse. The program took 3 years. Her certification examination required a minimum of 225 words per minute at 95% accuracy. She finished at 247. Her first job was not as a court reporter at all. It was as a deposition transcriber for a small civil firm in Westbrook. $9.50 an hour. 8 in the morning until 6 in the evening, 5 days a week. She did not complain. She listened to 7 hours of recorded depositions per day, typed every single word, and built the muscle memory that would later make her one of the fastest reporters in the county. After 18 months, the firm wrote a letter of recommendation calling her meticulous, discreet, and possessed of an unusual gift for sitting still. In 1990, she applied for an official court reporter opening at the Ashford County Superior Court. The hiring panel asked her if she could handle long felony trials without losing her composure. She said yes. They hired her at $32,400 a year. She married a paralegal named Henry Delacroix in 1992. He worked for the Public Defender's Office. They bought a small Cape Cod on Camellia Street, 3 blocks from the courthouse, and lived there for the next 31 years. They had no children. Margot's evaluations during the 1990s used the same vocabulary again and again: reliable, discreet, detail-oriented, showed strong aptitude for complex multi-party proceedings, demonstrates exceptional accuracy under sustained pressure, works well independently and requires minimal supervisory oversight. By 2003, she had been promoted to the senior reporter pool, which meant she was first call for the county's longest and most complex felony trials. Capital cases, multi-defendant conspiracy trials, trials with sealed witnesses and protective orders. She covered them all. Her transcripts were filed on time. Her certifications were never challenged. She became, in the words of the chief court administrator, the person whose accuracy no one ever questioned because no one ever had reason to. That was the trust. That was the position. That was what she would eventually sell. The court reporter is the only person in a felony trial whose entire job is to make a permanent record of what happens. The judge presides, the attorneys argue, the witnesses testify, the jurors decide. But none of those people produce the document the appellate courts will eventually read. That document comes from one chair in one corner of the courtroom, occupied by one person. In Ashford County, the certified transcript is the legal record of every felony trial. When an appeal is filed, the appellate justices do not watch video of the trial. They do not listen to audio. They read the transcript. The transcript is presumed accurate. The transcript is presumed complete. The transcript is, in every practical sense, the truth of what happened in the room. The county did log courtroom audio. Every felony courtroom had a ceiling-mounted recording system that captured the proceedings as a redundant backup. The audio files were stored on a county server and retained for 7 years. But in 21 years of operation, no one had ever pulled them to verify a certified transcript. Why would anyone? The court reporter had already signed the document. The reporter's embossed seal sat on the cover page. That seal carried the full force of a sworn certification. The mechanism worked because the transcript outranked the recording. On appeal, the certified transcript was the operative record. Even if a discrepancy existed in the audio, the appellate court would defer to the reporter's certification unless someone moved formally to challenge it. No one ever did. Defense attorneys did not pull the audio. Prosecutors did not pull the audio. The clerk of court did not audit the audio. The county had built a redundant safeguard, then designed a system that never used it. Marguerite Delacroix understood this better than anyone in the building. She had been the senior reporter for 13 years. She knew which judges signed off without reading the transcript. She knew which clerks filed without checking the page count. She knew the county's audio retention policy by heart, and she knew that in her entire career, not a single one of her certifications had ever been pulled and verified against the recording. Not once. Her stenographic notes were her property until certification. Her drafts lived on her personal laptop. The final transcript she produced was the only version that mattered, and she alone decided when it was finished. Once she signed it and embossed it with her certified seal, it became the official record of the proceeding. From that moment forward, what she typed outranked what the witness had said. The institution depended on her honesty. The institution did not verify her honesty. And in the gap between those two facts, she found the room to operate. The first altered transcript was a 2019 burglary case. The defendant was a 26-year-old man named Curtis Aldridge, accused of breaking into a hardware store on Riverside Avenue and taking approximately $4,200 in power tools. The state's case rested on the testimony of a single eyewitness, a neighbor who had watched from her porch and identified Aldridge by his face, his jacket, and the limp he carried from an old motorcycle accident. Aldridge's family approached a man named Robert Hennessy, a defense intermediary who had worked the margins of the Ashford County Courthouse for 15 years. Hennessy was not a lawyer. He was a paid go-between, a person who knew which clerks could be persuaded to misfile motions and which bondsmen would extend credit on a handshake. He had also, over the years, come to understand that Marguerite Delacroix was tired, underpaid, and approaching the end of a career that had given her no real savings cushion to retire on. The first conversation happened in the courthouse parking lot in October 2019. Hennessy did not ask her to lie under oath. He did not ask her to forge a document outright. He asked her, in his own words, to soften the eyewitness's identification, to add a hedge, to insert the phrase "I think" before the word "him," to turn certainty into doubt. He offered her $7,500 in cash. She accepted. The alteration took her less than 10 minutes at home that evening. The witness had said, on the audio, "It was Curtis. I saw his face. I am 100% sure. Margot's certified transcript read, I think it was Curtis. I saw his face. I am fairly sure. The phantom qualifier was small. It looked like ordinary speech. It would have read, to any appellate justice who reviewed it, as a witness who was perhaps a little less certain than she had appeared on cross-examination. Aldridge was still convicted. The transcript alteration did not change the verdict. But Hennessy had paid the money, and he had learned what Margot would do, and the next request came 8 months later. The second case was an aggravated assault trial in early 2022 involving a defendant named Marcus Pell. Pell had allegedly fired a handgun at a man outside a tavern called the Iron Lantern. The state's key witness, a bartender named Denise Whaley, had testified on direct examination that she watched Pell raise the gun, aim it, and pull the trigger. Her exact words on the audio were, I saw him fire the gun. I saw it. In the certified transcript, Whaley's testimony read, I saw him with the gun. It was dark. I'm not certain what happened next. Margot had deleted the words, fire the gun, entirely. She had inserted the phantom qualifier, it was dark, and the hedge, I'm not certain what happened next. She had then adjusted the line and page numbering so that no visible gap existed in the record. The pages flowed perfectly. The transcript looked clean. And in the absence of anyone cross-checking against the audio, the doctored version was the only version that existed. Hennessy paid her $22,000 for the Pell alteration. The third and fourth cases followed similar patterns. A drug trafficking case in mid-2022, in which a confidential informant's identification of the defendant was hedged into uselessness. Payment, $18,500. And a fourth case in 2023, a stolen property prosecution, in which Margot struck an entire exchange during cross-examination, then renumbered the pages so the record showed no gap. Payment, $36,000. The total, across the 4 altered cases, came to approximately $84,000. The payments arrived in 2 streams: cash, delivered in plain envelopes during brief meetings in the courthouse parking lot, and consulting deposits, routed through a small bookkeeping firm operated by Margot's cousin, a woman named Loretta Beauchamp, who ran her business out of a converted garage in the next town over. Loretta did not know the source of the deposits. She knew only that her cousin had asked her to receive payments from a list of clients and forward them on as consulting income. Loretta took a small handling fee. She filed the paperwork. She did not ask questions. By the spring of 2023, Margot had altered 4 felony trials, accepted $84,000, and convinced herself that the system she had served for 28 years was simply too overworked, too underfunded, and too uninterested in its own records to ever catch her. She was, in every measurable sense, right. She was right until she wasn't. In late August 2023, an appellate defense attorney named Eileen Brockway was assigned to handle the post-conviction appeal of Marcus Pell, the man convicted in the 2022 aggravated assault case. Brockway was a 12-year veteran of the State Appellate Defender's Office. She was thorough, she was methodical, and she had a habit, unusual in her profession, of always listening to the archived courtroom audio before drafting an appellate brief, even when the certified transcript looked perfectly clean. She did not expect to find anything. She rarely did. The audio was a courtesy, a redundant check, a way to hear the texture of witness testimony rather than just read it on the page. She pulled the audio for the Pell trial on a Wednesday afternoon and listened to it in her office while drafting notes on her laptop. She had the certified transcript open beside her, line by line. She followed along as Denise Whaley took the stand. Direct examination, cross-examination, the state's questions, the defense's questions, and then she heard it. On the audio, at the 11-minute mark of Whaley's direct testimony, the bartender said clearly, I saw him fire the gun. I saw it. Her voice was steady. There was no hesitation, no qualifier, no reference to the dark, no expression of uncertainty. Brockway looked at the transcript. The transcript said, I saw him with the gun. It was dark. I'm not certain what happened next. She rewound the audio and played it again. I saw him fire the gun. I saw it. She rewound again. Same words, same clarity, same flat, confident delivery. She stared at the transcript for a long time. Then she pulled the rest of the audio for the entire trial and spent the next 3 days going through it sentence by sentence, comparing every key passage against the certified record. She found more discrepancies, phantom qualifiers, inserted hedges. One passage where an entire exchange during cross-examination had been removed and the pages renumbered to hide the gap. On the morning of the 4th day, Brockway walked into the office of the presiding judge of the Ashford County Superior Court, a 62-year-old jurist named Harlan Westbrook, and laid the certified transcript and the audio recording on his desk, side by side. She did not say what she suspected. She told him only that there was a discrepancy and that he should listen for himself. Judge Westbrook listened for 45 minutes. He did not speak when the recording ended. He picked up his phone, called the county clerk's office, and ordered every felony case Marguerite Delacroix had reported in the prior 3 years to be pulled and audited against the archived audio. The order went out that afternoon. The first audits were complete within 72 hours. By the end of the week, the clerk had identified 47 separate divergences across 9 different cases. The pattern was unmistakable. The discrepancies were not transcription errors. They were systematic. They were deliberate, and every one of them was signed and sealed by the same certified court reporter. We're heading into the investigation now. If you've made it this far, that's because the story deserved to be told properly. Subscribe if you agree. The verdict in this one will surprise you, and the sentencing statement at the end is one of the hardest I've read on this channel. The investigation was assigned to the State Attorney General's Public Integrity Unit, which operated out of a small office in the Capitol and specialized in corruption cases involving public officials. The lead prosecutor was an Assistant Attorney General named Daniel Marchetti, a 15-year veteran of the unit with a reputation for thoroughness and a particular interest in cases involving the integrity of the court system itself. Marchetti's team began by sequestering every piece of physical and digital evidence connected to Marguerite Delacroix. They served a search warrant on her home office on Camellia Street on a Thursday morning in October 2023. They seized her work laptop, her personal laptop, 2 external hard drives, 3 stenotype machines, 23 years of physical paper drafts stored in filing boxes in her basement, and a small fireproof safe that contained $6,000 in cash and a handwritten list of case names. The forensic audit of her stenographic backups took 11 weeks. The investigators recovered earlier, unaltered drafts of every transcript in question. The drafts matched the audio recordings exactly. The certified versions did not. In every instance where a divergence existed in the certified transcript, the original draft on Margot's hard drive showed the original, accurate testimony intact, with deletion markers and revision timestamps documenting when she had edited the file before certification. The evidence was, in the words of one investigator, devastating. It was not a question of whether the alterations had occurred. The drafts proved they had. It was only a question of why. The financial investigation took longer. Marchetti's team traced the consulting deposits routed through Loretta Beauchamp's bookkeeping firm back to their original sources. 2 of the deposits originated from bank accounts held by family members of Marcus Pell. A 3rd deposit was traced to a relative of the defendant in the drug trafficking case. The 4th altered case generated a deposit routed through 3 intermediaries, but the final source was identified as Robert Hennessy, the defense fixer, using funds drawn from a slush account he had maintained for years. The investigators also recovered text messages. Margot and Hennessy had communicated through an encrypted messaging application that Margot apparently believed was secure. It was not. The forensic technicians recovered the message history from her phone backups. The exchanges were not subtle. Hennessy, March 14, 2022, Pell case, Whaley testimony, soften the gun ID, Delacroix, March 14, 2022, how much? Hennessy, March 14, 2022, 22 even, cash plus the usual routing. Delacroix, March 14, 2022. Send half before I certify, other half after. Hennessy, March 15, 2022. Done. And later, after the Pell certification was filed. Hennessy, April 8, 2022. Beautiful work. No one will ever pull the audio. Delacroix, April 8, 2022. No one ever does. Loretta Beauchamp, the cousin who had routed the deposits, was interviewed by investigators in November 2023. She broke quickly. She acknowledged that the deposits had passed through her business, denied any knowledge of their criminal source, and produced records that corroborated her account. She was offered a non-prosecution agreement in exchange for her testimony. She accepted. Robert Hennessy was arrested 2 weeks later. He hired a lawyer, refused to cooperate, and was indicted separately on charges of bribery, conspiracy, and obstruction of justice. By the time the indictment came down on Marguerite Delacroix, the case against her was airtight. The certified transcripts, the original drafts, the audio recordings, the financial trail, the text messages, the cousin's statement, the fixer's involvement. Every element of the scheme had been documented in writing, or in deposits, or in her own keystrokes. There was nothing left to investigate. There was only the matter of the confrontation. They arrived at her home on Camellia Street at 6:47 in the morning on a Tuesday in February 2024. 2 investigators from the Attorney General's office, a uniformed deputy from the Ashford County Sheriff's Department, and a representative from the court administrator's office. The temperature outside was 28 degrees. The sky was the color of old aluminum. Frost had formed on the windshields of every car parked along the block. Margot answered the door in a navy blue cardigan over a white blouse, her gray hair pinned back the way she had worn it to work every day for 30 years. She was already dressed. She had been awake for hours. She had been awake, in fact, most of the night. The lead investigator, a woman named Sergeant Karen Pfluger, identified herself and presented the arrest warrant. She asked Margot to step outside. Margot, I know why you're here. My voice is steady. My hands are not shaking. Pfluger, Mrs. Delacroix, we have a warrant for your arrest on multiple felony charges, including bribery of a public official, tampering with public records, obstruction of justice, and forgery. Do you understand? Margot, I understand. Pfluger, do you wish to make a statement at this time? Margot paused for a long moment. She looked past Pfluger, down Camellia Street, toward the spire of the courthouse 3 blocks away. She had walked that route every weekday morning for 31 years. She had walked it through pregnancies that had ended in nothing. She had walked it through her husband's cancer treatment and his return to work. She had walked it through $84,000 of bribes and 4 altered trials and the slow, accumulating certainty that no one would ever notice. She turned back to Pfluger. Margot, I knew the day she pulled the audio. I knew the moment I heard her name. I just kept hoping she wouldn't actually listen. Pfluger, whose name, ma'am? Margot, Brockway, the appellate attorney. She always listens. Everyone else just reads. Pfluger said nothing. Margot, I would like to speak to my attorney before I say anything else. She extended her wrists. The deputy applied the handcuffs in front of her body, as a courtesy. They walked her to the unmarked sedan parked at the curb. Her husband, Henry, watched from the front window, holding a coffee mug, saying nothing. He had known for 3 months. She had told him the night the search warrant was executed. He had not left her. He had not spoken to her about it either. The car pulled away from Camellia Street at 7:03 in the morning. By 8, she was in a holding cell at the county jail, her certification suspended, her career over, and the official record of every trial she had ever touched now under formal review. The indictment was filed on February 12, 2024, in the State Superior Court. The grand jury returned 47 counts across the 4 altered cases: bribery of a public official, tampering with public records, obstruction of justice, forgery. Each altered transcript generated its own count cluster. The defense intermediary, Robert Hennessy, was named as co-defendant in a parallel indictment. Margot retained a defense attorney named Philip Marston, a former state prosecutor who specialized in white-collar and public corruption cases. Marston reviewed the evidence for 3 weeks. He met with Margot twice. At the end of the second meeting, he told her, in the bluntest possible terms, that the case could not be tried. The audio recordings existed. The original drafts existed. The financial trail existed. The text messages existed. There was no defense. He recommended she negotiate a plea. The plea negotiation took 4 months. The state's initial offer included a recommended sentence of 12 years in state prison, plus full restitution. Marston counter-offered 7. They settled at 9 years, with the state agreeing to dismiss the remaining counts in exchange for her guilty plea on the lead bribery and records tampering counts, and her full cooperation in the prosecution of Robert Hennessy. The sentencing hearing was held on August 22, 2024, in courtroom 4B of the Ashford County Superior Court, the same courtroom where Margot had reported 11 different felony trials over the years. The judge was Harlan Westbrook, the same jurist who had ordered the original audit 14 months earlier. He had recused himself from any case Margot had reported during the investigation, but he had specifically requested to preside over her sentencing. 3 victim impact statements were read into the record. Marcus Pell's mother, Deborah Pell, addressed the court first. Her son had served 16 months of his sentence before the altered transcript was discovered. His conviction had been vacated and his case scheduled for retrial. Deborah Pell. She took my boy's words and rewrote them. She decided what a witness said. She decided what the jury never got to hear. She is the reason my son spent a year and 4 months in a state prison for a verdict that was based on a lie she typed. The second statement came from an appellate justice who had ruled on one of the affected appeals based on the altered transcript. He had since reviewed the original audio. His written statement, read aloud by the prosecutor, called Margot's conduct an attack on the foundation of the appellate process itself. The third statement came from Denise Whaley, the bartender whose testimony had been altered in the Pell case. Denise Whaley. I sat in that witness chair and I told the truth. I told it the way I saw it. And she stole my words and gave me different ones. She made me into a witness I wasn't. She made me into a liar. And I didn't even know it had happened until a stranger called me on the telephone 2 years later. Judge Westbrook addressed Margot directly before pronouncing sentence. Judge Westbrook. Mrs. Delacroix, you held one of the most quiet and most powerful positions in this courthouse. You were the hand that turned spoken testimony into the permanent legal record. The institution trusted you because the institution depended on you. Every verdict you certified rested on the assumption that you were honest. Every appeal that flowed from this building rested on that same assumption. You sold that trust for $84,000. You rewrote what sworn witnesses said. You changed the testimony that decided whether a man went to prison or went home. You did not do this once in a moment of weakness. You did it 4 times over 4 years. You did it deliberately, and you did it for money, and you did it knowing that no one was watching. The court does not have the authority to undo the harm you caused. The court can only sentence you for what you have done. She was sentenced to 9 years in state prison, ordered to pay $84,000 in restitution, permanently barred from any future court employment, and her court reporter certification was revoked for life. She was processed into the State Women's Correctional Facility at Riverside in September 2024. Her projected release date is in 2032. She will be 65 years old when she walks out. Robert Hennessy was convicted at trial in early 2025 and sentenced to 14 years. Of the 4 felony cases Margot Delacroix altered, 3 have been vacated and scheduled for retrial. The 4th remains under appellate review. The integrity of every one of the more than 900 trials she certified across her 28-year career is now under formal audit. The county estimates the audit will take 6 years to complete. The courtroom audio has been pulled for every single one of them. This case was disturbing. But the next case on the right-hand side is even more shocking. Click it now.